Okay, so our topic is comparison of bond and property law in Slovakia during the First Republic in the light of the General Civil Code, shortly ABGB. I will initially talk about the property regulation under the ABGB. The ABGB determines ownership in an objective sense. That is that paragraph 353 explains what can be the object of ownership, and paragraph 355 establishes the possibilities of acquiring ownership. The object of ownership is anything that can be distinguished as movable or immovable. In the ABGB, the definition of ownership does not correspond to the concept of a subjective right, although this concept is often found in doctrine. The ABGB defines property as an enumeration of everything that belongs to the owner. If one adds to this the aspect, everything that is not prohibited by the law is permitted. It can be said that as long as the owner does not violate the law, he can do whatever he wants with his property. If, however, ownership is restricted, a distinction must be made between restrictions in rem and restrictions in obligation. A restriction in rem must be obeyed by any third party, whereas a restriction in obligation binds only the specific owner to whom the restriction applies. For example, a land lease or an easement of use. In the Civil Code, the owner is limited by the prohibition of harassment, the peaceful use of his property. The prohibition against harassment means not to use one's property in a manner contrary to good morals. Thus, the owner is not restricted by a legal provision, but if he uses his property in a way that serves only to harm another, he must cease his actions. In the exercise of the duty to take precautions in an emergency, the owner of the thing in question cannot defend himself against the use of the thing by someone else if the other person averts an imminent danger from himself or another. This needs to be a temporary use of a thing, but also a use over a longer period of time. For example, the diversion of water from a suddenly gushing spring into someone else's water house. The limits of this duty are reasonable use and the impossibility of otherwise averting the danger. A limitation on the owner is also the prohibition not to disturb another owner's quiet enjoyment of his property under section 364. Other limitations on the owner are the so-called statutory easements, which are, for example, waterway obligations, the mooring and landing of boats. A thing is entitled to dispose of its benefits and substance. By benefits, we mean not only the fruits, but also any other benefits that the thing in question provides. For example, rent from apartments. The benefits of the owner thing belong only to him, but if he transfers the benefits to someone else, in the form of an easement or a bond, then of course the benefits belong to the other person. In the case of equitable possession, the holder may keep all the benefits of the thing arising during his possession, even if the holder has to return the thing to its rightful owner. Substance can be understood as the determination of the thing in economic terms, that is, that's property value, like land, vineyard, or quarry, or even wood, and subsequently chairs and chips, and so on. The owner may depreciate or even destroy his thing arbitrarily, but he must not thereby violate any of his obligations towards third parties. Next, I'll be talking about the ownership under private law in Slovakia. The concept of ownership in Slovakia is the same as in the ABGB because it is based on Roman, canon, and fief law. The opus tripartitum was created as a collection of particularistic jurisprudence. Both the ABGB and the Slovak law view property in the manner of modern codes. When comparing the prohibition of bullying, we can say that private law in Slovakia is similar and based on the general legal principle. Nemo audiatur turpitudinem suam allegans. That is where no obvious reason can be found. It cannot be said to be bullying. Such an obvious reason may be, for example, the exercise of a right for the purpose of obtaining a benefit that is disproportionate to the harm caused by the exercise of the right. A striking difference between the rights being compared is that of easements, which are regulated in specific legislation. There are no equivalents of these easements in Czech private law. They are, for example, under certain conditions, the transport of forest fruits over other people's land is permitted. We can see our paragraphs 178 to 180 of statutory article 31/1879. In the ABGB, only timber is mentioned. Here, the list is extended to all forest fruits. Each owner is obliged, in compensation for damages, to allow water to be let across his land on the basis of an official permit. Yards, gardens, and houses are exempt from this. Wells to be placed within the perimeter of the municipality must be built at least 3 meters from wells, springs, lakes, or houses. If a well is to be built outside the perimeter of the municipality, a distance of 15 meters from similar places mentioned above must be observed. That is in paragraph 14 of statutory article 31/1885. Slovak private law. Slovak private law views the institute of substance and use of a thing in the same way as private law in the Czech territory. Next, I will be talking about possession under the ABGB. The ABGB includes possession within the scope of rights in rem. This institution is very important, especially for the acquisition of ownership by possession, which will be discussed below. By possession, we mean a certain state of being in possession of a thing or having detention, corpus possessionis. And this person expresses his will by treating the thing as if it were his own, animus possidendi. The subject of possession may be any person who fulfills the requirements mentioned above. However, the ABGB provides exemptions to possession under paragraph 310 and paragraph 337 for persons who do not have a legally relevant will. For example, children or the insane. Or for persons for whom we cannot speak of a will in the proper sense, for example, like the legal persons. Another exception is provided by paragraph 311 of the ABGB, which provides that things that cannot be the subject of legal transaction are excluded from possession, and furthermore, if someone is incapable of being the subject of possession, he or she cannot have possession of the thing either. There are, for example, skeletal remains and things deposited with them. Only things that can be possessed can be the subject of possession. In addition to things, rights, easements, surface rights, heritable leases, rights to make mountains, water rights, um, rights of origin, for example, copyright, rights of obligation. If they are perpetual or re-exercised, liens can also be objects of possession. For the acquisition of possession of a right, the following conditions are necessary: the conception of the will of the acquirer to exercise the right as if it belonged to him, and the acquirer's will must be realized by the exercise of the right. Possession of a right is a permanent condition. That means the holder will have the will to hold the right only if it results in the permanent exercise of the right. The difference in the acquisition of possession can be seen in whether it is an acquisition of possession without the will of the existing holder, or whether it is an acquisition of possession with the will of the existing holder. In the case of acquisition of possession without the will of the former holder, possession can be acquired only by the actual exercise of the right of ownership. Possession of a thing which is not yet held by anyone may also be acquired in this way. Conversely, in the case of acquisition of possession with the will of the former holder, it is necessary that the former holder relinquish possession and the incoming holder expresses a will to dispose of the thing as if it were his own. Possession may also be acquired through an agent. In addition to the two basic conditions of possession, animus possidendi and corpus possessionis, the representative needs power of representation, which expresses the relationship between the represented person and the representative. There are two important requirements for disposing of possession. The first requirement is that the possessor expresses a will directed towards the expression of unwillingness to possess. However, it is necessary to place the thing in such a state that there is a clear and intelligible renunciation of possession. If the thing is merely neglected, there can be no question of abandonment. The second requirement is that the possessor cease to be able to dispose of the thing as his own, or someone else becomes possessor because the original possessor has been affected by the circumstances described in section 4 of the Civil Code, or the thing ceases to be capable of exercising the right of ownership, or the possessor ceases to be capable of holding the thing. Two circumstances are necessary for the cessation of possession of a right. The holder expresses his will that he no longer wishes to hold the right. The possibility of exercising possession ceases by the death of the holder or the disappearance of the thing which formed the basis for the possession of the right, or the counterparty prevents the exercise of the right. And finally, I will talk about the possession under private law in Slovakia. When comparing the institution of possession under the ABGB and private law in Slovakia, it can be found that the basic elements of possession are the same as the concept of both private rights based on Roman law. Both require corpus possessionis and animus possidendi for possession. The two compared laws distinguish between the concepts of possession and detention. It should be noted, however, that in the older private law in Slovakia, there was no distinction between possession and detention. The methods of acquiring possession are also the same, but in Slovak private law, we do not find an explicit distinction between tangible and intangible things. The distinction between these rights is found in paragraph 325 of the Civil Code, where the ABGB establishes the obligation to state the legal reason for one's possession, while political and criminal laws decide on this. In Slovak private law, this principle also exists, but in Slovak criminal law, there is no need to prove the legal reason for possession, and it is left to the accused how he wants to defend himself. As a result of the comparison of the two rights in regulating honest and dishonest possession, no major differences are found. In the Slovak regulation, there is a problem with the different approach of certain authors, because Linsky, as in the ABGB, grants the dishonest holder the right to compensation for both necessary and useful costs, whereas Almasi argues that the dishonest holder is only entitled to compensation for necessary costs. That means not for useful costs. A similar conflict between Slovak authors occurs in the use of the conversion of an honest holder into a dishonest one. The question is when an honest holder becomes dishonest, whether by serving the claim or by filling the claim. This solution is very important in determining the amount of costs. Slovak private law contains the institute of summary repossession, which is unknown to the ABGB. Summary repossession means the right of a person to request summary repossession. This request is conditional on the prior withdrawal of possession of the thing and the non-interest of the person requesting to take back the thing by himself. It is not a dispute over a right, and the claimant does not have to prove that he has the right to possess the thing. On the contrary, the defendant must prove that he had the right to take the thing for himself. The plaintiff may claim compensation for the loss of possession. This summary repossession can only be claimed by a person who has held the item for more than 1 year. This institution can lead to this absurd situation. The lawful possessor notices that someone else has occupied his land for more than a year, manages to evict him, but the evicted person succeeds with summary repossession, and the lawful possessor must bring an action for possession to regain lawful possession. This institution is not found in the ABGB, which rather emphasizes the problem of actions for the disturbance of possession and actions for ejectment from possession, that is, negatory actions and vindication. Certainly, none of the above actions of the Slovak regulation concerning possession are found in the ABGB. Finally, it is important to mention the protection of the holder against the construction of new properties or works. According to the ABGB, it is necessary that the court does not allow the construction to continue until a decision is issued, but exceptions to this are allowed according to paragraph 341, sentence 2, private law, sentence 2. A private law in Slovakia does not contain such a provision. Both legal systems provide the legal holder with the possibility to defend his rights to possession. Under Slovak private law, the holder has a 1 year period for such action, whereas under the ABGB it is only a 30-day limitation period. Slovak private law does not have the same or a similar equivalent to the wording of paragraph 347 and 348, which provide that if it is not clear to whom the thing belongs in a dispute over possession, it shall be entrusted to the custody of the court or a third party, and if the owner is approached by several claimants for possession of the thing, the owner shall entrust possession to the one in whose name the thing was kept. If this fact is not known, the thing shall again be entrusted to the custody of the court or a third party.
Bond law under ABGB and private law in Slovakia. The law of obligations in the Czech territory was mainly based on the ABGB, which was amended between 1914 and 1916. In the Slovak part of the country, on the other hand, there was no code that would have covered the law of obligations in such a comprehensive manner. Both laws were partly included by commercial law. In Slovakia, however, there were only individual laws which mainly regulated employment contracts. During the First Republic, it was the employment contract in Slovakia that was regulated by Act number 244/1922 call, which was almost verbatim with the provisions of the ABGB, which led to unification of labor law in Czechoslovak civil law. All existing customary and written provisions relating to employment contract were abolished except for these provisions which were in favor of the employee compared with the provision of the ABGB. Formation of a bond under ABGB. For a bond to arise, it is necessary that one person has obligate another person to perform a duty, and the special reasons have been given for this. These special reasons include a legal act, damage suffered, facts of a very different nature, and the official act. A legal act can be understood as either a contract of obligation or an unilateral legal act. Obligatory contracts will be dealt with in the following chapter. We can apply unilateral legal act only in exception cases. In particular, we can understand a public promise but also an assignment or a ratification. The ABGB presents damages suffered as a consequence of unlawful act or torts, which are dealt with in the 32nd title, section 1293 section. The ABGB contract of obligation. A contract of obligation can be defined as a bilateral legal act transaction which creates a bond obligation of one or both parties to contract. The basis of a bond contract is a certain effort to satisfy one's need with the help of another person, and this effort will only be successful if the other person receives something in return. The parties to this contract make promise to each other and the subsequent perform. This takes place for certain reasons, and therefore we can distinguish several types of bond contracts. Bond contracts can be divided into casual and abstract, formal and formals, named and unnamed, pledged and gratuitous, unilateral and bilateral. According to the ABGB, children under the age of 7 and the mentally ill are not eligible to enter into the bond contract. We consider as insane these who are so designed by the provisions of the Code on the deprivation of legal capacity and are deprived by the court of the capacity, to enter into bond contracts on the basis of the provisions. It may, however, by that the person has not yet been deprived of capacity before entering into the contract, with the result that is impossible to enforce performance under the bond contract entered into because they are void. Persons may have a limited capacity to enter into a bond contract, and we consider such a person to be those who have reached their 7th years of age and have not reached their 21st year of age, or adults, whose capacity has been limited by a court order. The object of the law of obligations is often defined as a performance which must have a property value. However, this definition is not entirely precise. The subject matter of a bond may be defined negatively as follows: the subject matter of a bond cannot buy acts which, according to prevailing social opinion, can only buy the result of the free decision of an individual, so that it would be contrary to this social opinion if legal rules were to provide for their fulfillment. The ABGB prohibits the conclusion of contracts which are contrary to the law in force of the good morals. Such contracts include, for example, a contract of consideration for the mediation of a marriage contract, or a contract that always exploitation on the basis of unreasonable consideration gambling. The parties may also agree ancillary provisions to individual contracts. The contract of obligation is a bilateral legal act which results in an obligation of one or both parties to the contract. The individual acts of the parties usually do not fall within a single time period. The first manifestation is called an offer or offerta, and the subsequent acceptance by the other party is called an acceptance. It is necessary that the acceptor accept the offer exactly as it was offered, because if he changes the offer in any way, it will be another offer, this time directed at the original offerer. Any agreement of the parties for which bond obligation are to arise must take some from presenting itself to the outside world. Under the provisions of Section 883, any manifestation will usually suffice if it shows the existence and cannot of the decision. However, it may be necessary for the contract to take a certain form arising for the law of the agreement of the parties. If some from consensus is required, to law usually provides for a written from a contract or a written expression of one of the contracting parties. Other forms of contracts include the establishment of a list when entering into a partnership agreement for the future or a present assets. Another form of contract is a notario deed drawn up on the contract in question.